Hello students, myself is Puneet from Prab classes. In this course, we are going to study class 11 Business Studies, chapter number 2, Forms of Business Organizations. Whenever a person decides to start a business, he has to find answers to certain questions such as what type of business he should do, from where he will get capital to finance the business, which type of form of business organization he should choose, and many other related questions. This course relates to only forms of business organizations. So let us start. In this course, we will discuss number 1. What are the various forms of business organizations? Number 2. What is meant by sole proprietorship? Give two examples of sole proprietorship. Third, what are the various features of sole proprietorship? Fourth, what are the merits and limitations of sole proprietorship? Fifth, is sole proprietor the same as self-employed? Sixth, what is the meaning of joint Hindu family business? Who can be a member of a joint Hindu family business? Seventh, what is meant by karta and co-partner? 8. What are the various characteristics of joint Hindu family business? Next, how the business continues even after the death of Karta in case of joint Hindu family business. 10. What are the various merits and limitations of joint Hindu family business? 11. How is a Karta appointed in a HUF? 12. Can a joint family business be dissolved? 13. Can a minor become a member of the Hindu undivided family business? 14. What is the difference between members and co-partners in a joint Hindu family business? 15. Can a woman become the karta in the Hindu undivided family business? Next, what is the meaning of partnership? What are the various features of partnership? Next, what it is suggested to have a written agreement in case of partnership. 18. What are the various advantages and limitations of a partnership firm? 19. What are the various types of partners? Next, what is the meaning of partner by estoppel and partner by holding out? 21st. What are the types of partnership on the basis of duration? 22nd. What is the difference between general partnership and limited partnership? 23rd. What is the meaning of limited liability partnership? 24th. What is the meaning of partnership deed? Which are the normal points which are included in a partnership deed? 25th. Write a note on the registration of a partnership firm. 26th. What is the procedure followed in India to get the firm registered? Forms of business organization. When we plan to start a business or want to expand the existing business, we have to take an important decision which relates to the choice of the form of organization. We can decide to opt for a particular form of organization, keeping in view the features, advantages and disadvantages of different forms of business organization. Various forms of business organizations from which one can choose the right one are as under: A. Sole proprietorship. B. Joint Hindu family business. C. Partnership. D. Cooperative societies and joint stock company. Next, in this picture, we have shown different forms of business organizations, that is sole proprietorship, joint Hindu family business, partnership firm, cooperative society and joint stock company. We will discuss each form of business organization one by one. Sole proprietorship. As the name suggests, sole means only one, and proprietorship implies ownership. Hence, a sole proprietorship refers to a form of business organization which is owned, managed, and controlled by a single individual. A sole proprietorship is also known as a sole tradership or individual entrepreneurship. In a sole proprietorship, there is no legal distinction between the individual and the business owner. The owner is entitled to all profits from the business. He is also responsible for the business debts, liabilities, and losses. A sole trader does not necessarily work alone and may employ other people. Sole proprietorships are popular because of the simplicity of getting started. The individual who operates the business is known as a sole proprietor or a sole trader. If you go to a small neighborhood stationery shop or beauty parlor or hair salon, then in all probability you have interacted with the sole proprietor. Example, Rahul owns a retail shop. As his business picked up, he purchased goods for the shop for a sum of rupees 5 lakhs to be sold in next several months and payment to be paid to creditors in monthly installments. After 3 months, a large factory near his shop closed, laying off 500 employees. His sales decreased and he is finding it difficult to make the payments to his creditors. Here, this is an example of sole proprietorship of the business. Rahul is personally liable for the debt. The creditors can file a civil suit against Rahul and recover their dues from his business assets as well as his personal property, including his home, car, etc. What begins as a sole proprietorship may be converted into another, more complex business structure, such as a corporation, if the business grows significantly and begins hiring a large number of employees. Sole proprietorships are easy to establish and dismantle due to lack of government involvement. The owner pays personal income tax on profits earned from the business. This picture depicts the features of sole proprietorship. We will discuss each of these features in some detail. Features of sole proprietorship. Number one, easy commencement and closure. Hardly any legal formalities are required to start a sole proprietary business, though in some cases one may require a license or permit depending on his state and type of business. Owners can start or close a proprietary business at their discretion. Number two, one man control. Sole proprietor is in complete control of the business operations. He takes all the decisions and executes them in the manner he wants. Number third, no sharing of profit and loss. The risk of failure of business is borne all alone by the sole proprietor. However, if the business is successful, the proprietor enjoys all the benefits. Fourth, no distinction between the owner and the business. The business does not have a legal entity separate from the owner. Features of sole proprietorship. Fifth, unlimited liability. Sole proprietors have unlimited liability. This means that the owner is personally responsible for payment of debts in case the assets of the business are not sufficient to meet all the debts. As such, the owner's personal possessions such as his or her personal car and other assets could be sold for repaying the debt. Suppose the total outside liabilities of XYZ Dry Cleaner, a sole proprietorship firm, are rupees 80,000 at the time of dissolution, but its assets are rupees 60,000 only. In such a situation, the proprietor will have to bring in rupees 20,000 from her personal sources, even if she has to sell her personal property to repay the firm's debts. It does not matter whether the personal property or assets are generated from business revenues or not. 6. Lack of business continuity. The sole proprietorship business is owned and controlled by one person. The business ends up at his will or on his demand. Merits of sole proprietorship. Number 1. Quick decision making and prompt action. Sole proprietor is in complete control of the business. The decision making is quick because there is no need to consult others. This may lead to timely action to take advantage of market opportunities as and when they arise. Number 2. Confidentiality of information. Sole proprietor himself takes all decisions so he can keep all the business related information confidential. A sole trader is also not bound by law to publish firm's accounts. Third, close personal relation with the clients. Fourth, direct incentive. A sole proprietor is the sole beneficiary of all the profit. This provides maximum incentive to the sole trader to hard work. Ease of formation and closure. It is possible to start sole proprietary business with minimal legal formalities. Owners can start or close a proprietary business at their discretion. 6. Tax advantage. The sole proprietor pays only the personal income tax on the profits earned by the entity. The entity itself does not have to pay income tax. Limitations of sole proprietorship. Number 1. Limited resources. Resources of a sole proprietor are limited to his or her personal savings and borrowings from others. Banks and other lending institutions may hesitate to extend a long-term loan to a sole proprietor. Further, the owner cannot sell an equity stake to obtain new funds. Number 2. Limited life of a business concern. The sole proprietorship business is owned and controlled by one person, so that insanity, imprisonment, physical ailment, or bankruptcy of a proprietor affects the business and can lead to its closure. Third, limited size. Sole proprietorship will not earn the economies of scale due to its limited size. Fourth, unlimited liability. The business owner faces unlimited personal liability for all debts incurred by the entity. If the business fails, the creditors can recover their dues not merely from the business assets but also from the personal assets of the sole proprietor. So a sole proprietor is less inclined to take risks in the form of innovation or expansion. Fifth, limited managerial ability. The owner has to perform many managerial tasks such as purchasing, selling, financing, marketing, etc. It is rare to find an individual who is excellent in all these areas. So decision making in the case of sole proprietorship may not be logical in all the cases. Further, due to limited resources, sole proprietor may not be able to employ and retain talented and ambitious employees.
Conclusion. The sole proprietorship suffers from various shortcomings. Many entrepreneurs opt for this form of organization because of its various advantages. This form of business organization is particularly suitable for those businesses where manual skills are required or where the capital required to start the business is relatively small. For example, if we start a Kirana shop or a beauty parlor in our neighborhood, then it does not require a lot of capital. We have to imply only minimum capital. Further, this form of business does not involve a high degree of risk as we imply only limited capital, so the risk involved is also limited. This form of business, that is sole proprietorship form of business, is also suitable for those businesses where customers demand personalized services. Now, an important question arises whether sole proprietor is the same as self-employed. Answer is yes. A sole proprietor is the same as self-employed. A sole proprietor does not work for any other person or any other company. He does not have any boss. He works just for himself or herself. Hence, the sole proprietor is self-employed.
Joint Hindu family business. Joint Hindu family business is a specific form of business organization which is found only in India. It refers to a form of organization wherein the business is owned and carried on by the members of a joint Hindu family. This type of business is governed by the Hindu law. This business is also known as the Hindu Undivided Family Business or HUF business. Who can be a member of a joint Hindu family business? The basis of membership of the joint Hindu family business is birth in a particular family. Three successive generations can be members of the Hindu Undivided Family Business. Karta. Joint Hindu family business is controlled by the head of the family who is the eldest member and is called Karta. He has full control over the business of the family. He has all the right to take necessary decisions in the business. However, the Karta of HUF can take the advice from all the members but is not bound by law to accept their decisions or opinions related to the business. Liability of Karta is unlimited and rest all have liability as per their share in the business. Co-partner. All members in a Hindu undivided family have a legal right over the ancestral property by birth and they are known as co-partners, while their share keeps on changing with new additions into the family. Both sons and daughters are co-partners in the family. A daughter remains a co-partner in the property even after marriage and in case of her demise, her children become co-partners in her share. Features of joint Hindu family business. The characteristics of joint Hindu family business are as under. Number one, formation. For a joint Hindu family business, there should be at least two members in the family. There must be some assets or ancestral property inherited or to be inherited by them. The formation of this business does not require any documentation or agreement as membership is by birth. It is governed by the Hindu Succession Act 1956. Number two, liability. The liability of all members except the Karta is limited to their share of the property or business. The Karta, however, has unlimited liability. Third, control. The entire control of the family business lies with the Karta. He takes all the decisions and is authorized to manage the business. His decisions are binding on the other members. Fourth, continuity. The business continues even after the death of the Karta as the next eldest member will become the Karta and the business remains stable. However, the business can be dissolved with the mutual consent of the members. Fifth, minor members. If a person takes birth in a HUF, He becomes member of the HUF business. Hence, minors can also be members of the business. 6. Gender equality in the joint Hindu family a reality. Both sons and daughters have a legal right over the ancestral property by birth. A daughter remains a co-partner in the property of a joint Hindu family even after marriage, and in case of her demise, her children become co-partners in her share.
Now, an important question arises whether daughters have rights on property of HUF. In India, the legal position is this that before 2005, daughters were not having rights on the property of HUF. An amendment was made in 2005 in the Hindu Succession Act, which has conferred equal rights upon the daughters. Now, daughters have equal rights as sons in the properties of Hindu undivided family. The eldest member of the family, whether he is male or female, he or she shall become Karta. Married daughter has equal rights in the property of a joint Hindu family.
Merits or advantages of joint Hindu family business. Number one, effective control. The Karta of the family has full control over the family business. He has all the rights to take necessary decisions in the business. This leads to prompt and effective decision making. Second, continued business existence. The death of the Karta will not affect the business as the next eldest member will then take up the position and start taking the decision for the family business. So the business activities run smoothly and continuously. Third, limited liability of members. Only the Karta of HUF has unlimited liabilities against the business of the family. The liability of all the co-partners except the Karta is limited to their share in the business. So if the business takes any loss, only Karta's personal assets will be liable to pay debts of the business. Fourth, increased loyalty and cooperation. Since the business is run by the members of a family, there is a greater sense of loyalty and cooperation towards one another. Limitation of joint Hindu family business. Number one, limited resources. The joint Hindu family business faces the problem of limited capital as this model of business does not allow external members or additional participants other than the family members. So there is no space for additional capital or investments from the market. This limits the scope for expansion of business. Number two, unlimited liability of Karta. The Karta has the responsibility of decision making and also management of business. He also suffers from the disadvantage of having unlimited liability. His personal property can be used to repay business debts. Third, dominance of Karta. The Karta dominates the family business. He is not bound by any law to accept the decisions or opinions of other family members. This may cause conflict amongst them and may even lead to breakdown of the family unit. Fourth, limited managerial skills. Karta is the senior most family member but may not always be the most qualified member of the family. Since the Karta cannot be an expert in all areas of management, the business may suffer as a result of his unwise decisions. The joint Hindu family business is on the decline because of the diminishing number of joint Hindu families in the country. Do you know how is a Karta appointed in a HUF? There is no formal procedure for appointment of the Karta in a HUF. The eldest member in HUF is Karta. A Karta continues to remain the head of a HUF even if he is not physically fine. On the death of the Karta of the HUF, the eldest surviving co-partner in the family automatically becomes the Karta. However, a junior member of the family can also be a Karta if all the members of the family vote to appoint him as such. Can a joint family business be dissolved? Yes, if all the members of the Hindu undivided family agree to dissolve the business of the joint family, the business can be dissolved. Can a minor become a member of the Hindu undivided family business? Yes, the minor who took birth in the Hindu undivided family is eligible to become a member of his family business. However, he will not be liable for any loss, but he can enjoy all the benefits from the business.
Now we will understand the difference between members and co-partners. It is important to note here that an HUF has both members and co-partners, while the former, that is members, become part of the HUF through matrimonial alliances. The latter, that is co-partners, become members by way of birth. So as soon as a son or daughter is born in a Hindu undivided family, he or she becomes a member as well as a co-partner of a HUF. The wife or husband of a co-partner, for instance, is a member but not a co-partner in the HUF. So, while all the co-partners are members, not all the members are co-partners.
Who will continue the joint family business after the death of Karta? After the death of the Karta, the next eldest member of the HUF will become the Karta and he will continue the family business. Can a woman become the Karta in the undivided family? The Delhi High Court held the landmark ruling in 2017 in which the High Court held that the female members of the Hindu undivided family can also become the Karta in the Hindu undivided family.
Now we will conclude this concept of joint Hindu family business. A joint Hindu family business is an organization in which only the members of a family, male and female both, can manage and own the business. No outsider is allowed to participate in this business. Karta, who is the eldest member of the family, is the head of the family and he manages all the affairs of the business. He runs the business on behalf of other members of the Hindu undivided family. Joint Hindu family business is only practiced in India.
Partnership. Sole proprietorship suffers from some disadvantages like limited resources and limited managerial ability. This paved the way for partnership as a viable option. Partnership provides an answer to the needs of greater capital investment, various skills, and sharing of risks. Partnership is an agreement between two or more persons to carry on business with profit motive. The business is carried on by all the partners or any one of them acting for all. Or a partnership business consists of two or more people who combine their resources to form a business and agree to share risks, profits, and losses in certain proportions. The terms and conditions of a partnership are usually mentioned in the partnership deed. Features or characteristics of partnership. Number one, formation. The formation of the partnership business is very easy. Two or more persons can form the partnership business by way of a written or verbal agreement. In order to avoid controversies, it is suggested to have written agreement wherein the terms and conditions governing the relationship among the partners, sharing of profits and losses, and the manner of conducting the business are specified. Number two, unlimited liability. The liability of every partner is unlimited. Personal assets may be used for repaying debts in case the business assets are insufficient. The partners are jointly and individually liable for payment of debts. Third, business motive. The partnership business must be run with the motive of profit. So, if two or more people come together and put money in some charitable work, then it will not be regarded as a partnership business. Fourth, lawful business. The business to be carried on by a partnership must always be lawful. Fifth, sharing of profit or losses. The profits or losses of the business are shared by the partners in an agreed ratio. For example, three partners named A, B, and C have started a business by investing a total of $1 lakh, out of which $50 are paid 50,000. $50,000 are paid by A and $25 paid by B and C each. The percentage share in the profit or loss will be 50%, 25%, and 25% respectively. 6. Decision making and control. Decisions are generally taken with mutual consent. The activities of a partnership firm are managed through the joint efforts of all the partners. However, the responsibility to manage the business can be put on the shoulders of a business partner who is willing to take responsibility and has enough time and skills too. 7. Continuity. Partnership is characterized by lack of continuity of business since the death, retirement, insolvency, or insanity of any partner can bring an end to the business. However, the remaining partners may, if they so desire, continue the business on the basis of a new agreement. 7. Number of partners. The minimum number of partners needed to start a partnership firm is 2. Business partners can be two strangers and can be belonging to the same family. However, there is a limit on the maximum number of partners which can get involved in the partnership business. Ninth, mutual agency. Mutual agency means that each partner acts on behalf of the partnership and act of any partner is binding on all the partners. 10. Share in the partnership business cannot be transferred to an outside person without the consent of all the partners. Merits or advantages of a partnership firm. Number one, ease of formation and closure. A partnership firm can be formed easily. A simple agreement, verbal or written, is enough to form a partnership firm. Closure of the firm too is an easy task. Number two, balanced decision making. The partners can oversee different functions according to their areas of expertise, and an individual is not forced to handle different activities. As a consequence, decisions are likely to be more balanced. Third, more funds. In a partnership, the capital is contributed by all the partners, so a large amount of funds is available for the business. Fourth, sharing of risk. The risks involved in running a partnership firm are shared by all the partners. This reduces the anxiety, burden, and stress on individual partners. Fifth, secrecy. A partnership firm is not legally required to publish its accounts and submit its reports. Hence, it is able to maintain confidentiality of information relating to its operations. Limitations of partnership business. Number one, unlimited liability. Each partner has unlimited liability. The liability of partners is both joint and several, which may prove to be a drawback for those partners who have greater personal wealth. They will have to repay the entire debt in case the other partners are unable to do so. Number two, limited resources. There is a restriction on the number of partners and hence capital contributed by partners is usually not sufficient to support large scale business operations. As a result, partnership firms face problems in expansion beyond a certain size. Third, lack of continuity. Partnership comes to an end with the death, retirement, insolvency, or lunacy of any partner. It may result in lack of continuity. However, the remaining partners can enter into a fresh agreement and continue to run the business. Fourth, poor decision making by one partner damages the interest of the other. Fifth, lack of public confidence. A partnership firm is not legally required to publish its financial reports or make other related information public. So it is difficult for any member of the public to ascertain the true financial status of a partnership firm. As a result, the confidence of the public in partnership firms is generally low. 6. Difficulty in withdrawing investment. Investment in a partnership can be simple, but its withdrawal may be difficult or costly. This is so because no partner can withdraw his interest from the firm without the consent of all partners. 7. Possibility of conflicts, lack of centralized authority, and difference in opinion between partners on some issues may lead to losing growth opportunities. Partnership deed. Partnership deed is an agreement between the partners of the firm which contains the terms and conditions of partnership between the partners. Such an agreement can be oral or written. It is not necessary to have a written agreement, but it is advisable to have a written agreement as it provides an evidence of the conditions agreed upon. The main purpose of a partnership deed is to describe the rights and obligations or duties of each partner. The Indian Partnership Act 1932 is the law governing partnerships in India.
Now we will cover now we will understand what are the particulars which are normally mentioned in the what partnership deed. First of all, the name of the firm is mentioned in the partnership deed. Then name and details of all the partners who have contributed capital to the firm are mentioned in the partnership deed. Then the nature and location where the business will be carried out is mentioned in the partnership deed. The other particulars like date of commencement of business, what will be the duration of the business, what will be the amount of capital which will be contributed by each partner, how the profit and losses will be distributed between the partners, what are the various duties and powers of the partners of the firm, whether any salary or commission will be payable to the partners or to some particular partners, what are the various terms and conditions which relate to the admission and withdrawal of a partner, and what should be the procedure which the partners have to follow in case there is a dispute on some matter between the partners, and if the partners want to dissolve the firm, what will be the procedure, how the accounts will be prepared, and how the accounts will be audited, and the method of calculating the amount due to a retiring partner or to the successor of a deceased partner. These are only general aspects. There may be many more aspects which may be required to be covered in a partnership deed on the basis of the Partner type of nature of business. Once the partnership deed is complete, all the partners have to sign and date the partnership deed. There may be also required the signing of the witnesses. Next, what types of businesses are best suited for partnerships? Partnerships are best for a group of professionals who are in the same line of work or where each partner has an active role in running the business. So, the best businesses which are suitable for partnership often include doctors, lawyers, accountants, and architects.
Types of partners. A partnership firm can have different types of partners with different roles and liabilities. These are described as follows. Number one, active partner. An active partner is one who contributes capital and plays an active role in managing the daily functions of the business. The active partner is also known as ostensible partner or managing partner. Sometimes he draws remuneration as salary for his hard work. He has unlimited liability. He shares profit and loss of the firm. Number two, sleeping or dormant partner. Partner who only contributes capital to the firm and does not take part in the day-to-day activities of the business is called sleeping partner. A sleeping partner, however, shares its profit and losses and has unlimited liability. Third, partner by estoppel. If a person through his or her own initiative, conduct or behavior gives an impression to others that he or she is a partner of the firm, he or she is called partner by estoppel. He does not take part in its management. He does not contribute capital. He does not share profit and loss. His liability is unlimited as in the eyes of the third party. He is a partner of the firm. Fourth, Ria is Ela's friend. Ela is a partner in a software firm, ABC Solutions. On Ela's request, Ria accompanies her to a business meeting with simple softwares and actively participates in the negotiation process for a business deal and gives the impression that she is also a partner in ABC Solutions. If credit is extended to ABC Solutions on the basis of these negotiations, Ria would also be liable for repayment of such debt as if she is a partner of the firm. Fourth, secret partner. A secret partner is actually a partner of the firm, but his association with the firm is unknown to the general public. He contributes to the capital of the firm, takes part in the management, but secretly shares its profits and losses and has unlimited liability towards the creditors. For example, if there is a press conference by the firm, he will not come on the dais of the partners. Fifth, nominal partner. A nominal partner is one who allows the use of his or her name by a firm and normally he gets a fees from the firm. These nominal partners are the most well-known individuals, businessmen, celebrities, etc., who allow their names to be added to the company to increase its goodwill. He does not contribute to its capital. He does not share its profit or losses. He does not take part in company's management affairs. His liability is unlimited. 6. Partner by holding out. A partner by holding out is a person who is not a partner in a firm but knowingly allows his name to be represented as a partner in a firm. His liability is unlimited. In case he is not really a partner and wants to save himself from such a liability, he should immediately issue a denial clarifying his position that he is not a partner in the firm. If he does not do so, he will be responsible to the third party for any such debt. He does not bring any capital. He does not share profit and loss. He does not participate in day-to-day functions of the firm. Under a partnership structure, you are jointly and individually responsible for the debts of your business partners. This means if one of your business partners are unable to pay a debt that they have incurred on behalf of the business, you may need to pay this debt yourself.
Now, we will understand the difference between different types of partners in the shape of a table. First of all is active partner. Active partner contributes to the capital of the firm. He participates in the daily management of the firm. He has his share in the profits and losses of the firm. Active partner has unlimited liability. In case of sleeping partner or dormant partner, it does not mean that he sleeps in his life always. It means that he does not care on what is going on in the organization. He does not, he contributes capital to the firm, but he does not participate in the day-to-day functions or the management of the company. However, he shares the profits and losses of the firm. He has unlimited liability. In the case of secret partner, though he is a partner in the firm and he contributes capital to the firm, but he secretly participates in the management functions of the firm. He has his share in the profits and losses of the firm and he has unlimited liability. Nominal partner, as already told, is normally a celebrity or a known person in the relevant field, in any field. He does not contribute any capital to the firm. He does not participate in the management of the firm. Generally, he does not share profit and losses of the firm. He has unlimited liability. Partner by estoppel does not contribute capital to the firm, nor he participates in the management of the firm. He also does not share profit and losses. He has unlimited liability. Partner by holding out also does not contribute capital. He does not participate in management and he also does not share in the profit and losses of the firm. He has unlimited liability. Now we will understand what is whether minor can be a partner in a firm. Partnership is based on a legal contract between two persons who agree to share the profits or losses of the business carried on by them. A minor is incompetent to enter into a valid contract with others because he is a minor, because he has not attained the age of maturity. So he cannot become a partner in any firm. However, a minor can be admitted to the benefits of a partnership firm with mutual consent of all the partners. In such cases, his liability will be limited to the extent of the capital contributed by him in the firm. He will not be eligible to take an active part in the management of the firm. He can share only the profits. However, if there are losses in the firm, the minor cannot be asked to bear the losses. However, a minor can inspect the accounts of the firm. As a minor becomes major, so far as the age is concerned, his status changes. In fact, on attaining majority in age, the minor has to decide whether he would like to continue to be the partner of the firm or would like to resign from the partnership of the firm. He has to give a public notice of his decision within 6 months of attaining majority. If he fails to do so within the stipulated time, he will be treated as a full-fledged partner. That is, if he does not want to become the partner or attaining the majority, he has to give a notice, public notice, that he does not want to continue to be the partner in the firm. But if he does not give such public notice within 6 months of attaining majority, then he will be treated as full-fledged partner and he will have unlimited liability in the same way as other active partners face the liability. So we can say that a partnership firm cannot be formed with a minor as the only other member.
Now we will discuss the types of partnership. Partnership can be divided on the basis of duration as well as on the basis of liability. On the basis of duration, partnership is of two types: partnership at will and second is particular partnership. On the basis of liability, partnership can be divided into general partnership and limited partnership. Now we will discuss the classification of partnership on the basis of duration. Number 1. Partnership at will. This type of partnership remains in existence at the will of the partners. In this type of partnership, there is no definite condition indicating how long the partnership will exist. It can continue as long as the partners want. Any partner may terminate a partnership at any time by giving a notice of withdrawal from partnership. Number 2. Particular partnership. This type of partnership is created just to carry out one project or to finish one task, say construction of a building or road. It dissolves automatically when the purpose for which it was formed is fulfilled. Now, our topic is classification of partnership on the basis of liability. Number 1. General partnership. In general partnership, the liability of partners is unlimited and joint. This means that the personal assets of the partners can be seized to settle debt obligations or lawsuits. Further, any partner may be sued for the business's debts. All the partners have the right to participate in the management of the firm, and their acts are binding on each other as well as on the firm. General partnerships are easy to dissolve. The business is dissolved if any of the partners declares bankruptcy or passes away. Registration of the firm is optional. Second, limited partnership. In limited partnership, there is at least one general partner who manages business and takes on unlimited liability. The remaining partners are limited partners who hold financial stakes in the business. They have limited liability. Limited partners cannot be held personally liable for the debts of the business as they do not actively manage it. Registration of such partnership is compulsory. Such a partnership does not get terminated with the death, lunacy, or insolvency of the limited partners. Limited partnership was not permitted in India earlier. The permission to form such partnership has been granted in 1991 so that small scale entrepreneurs may attract equity capital from friends and relatives who were earlier reluctant to help due to existence of unlimited liability clause in the partnership form of business. Limited liability partnerships are an extension of a GP. GP here stands for General Partnership. A limited liability partnership is a form of partnership where the partners have limited liability. Partners share risk and profit based on their investments in the business. LLP combines the flexibility of a general partnership with the limited liability of a company. In this form of partnership, no partner is responsible or liable for the misconduct or negligence of other partners. One big advantage of limited liability partnership is that the partners are not personally liable and cannot be forced to pay a business debt or liability with personal property or assets. In India, Limited Liability Partnership Act 2008 is broadly based on UK LLP Act 2000 and Singapore LLP Act 2005. In some countries, LLP must also have at least one general partner with unlimited liability. In US, some states restrict this form of partnership to certain professions such as lawyers, doctors, accountants. Registration of a partnership firm. Registration of a partnership firm means the entering of the firm's name along with the relevant prescribed particulars in the register of firms kept with the registrar of firms. It provides unquestionable proof of the existence of a partnership firm. In India, registration of a partnership firm is not mandatory under law. It is optional. In case a firm does not get registered, it is deprived of many benefits. The consequences of non-registration of a firm are as follows. A partner of an unregistered firm cannot file a suit against the firm or other partners. B. Unregistered partnership firm cannot file a suit against third parties. And C. The firm cannot file a case against the partners. Keeping in view the adverse consequences of non-registration of partnership firms, it is advisable to get the firm registered. According to the India Partnership Act 1932, the partners may get the firm registered with the registrar of firms of the state in which the firm is situated. The registration can be at the time of formation or at any time during its existence. Procedure to get the firm registered. The procedure to get the firm registered is as follows. Number 1. Submit an application on the prescribed format to the registrar of firms. The application contains the following particulars: name and location of firm, name and addresses of the partners, date when each partner joined the firm, duration of partnership. Application should be signed by all the partners. Some documents like PAN cards, address proofs of all the partners, and partnership deed have also to be submitted. Number 2. Deposit of required fees with the registrar of firms. Third, registrar after thorough examination of the documents will issue a certificate of registration.
If you like our video, please like, share and subscribe our channel. Thank you.